Hello and welcome to my podcast. I'm Zillur Rahman. In today's episode, we take a deep dive into one of the most consequential developments in Bangladesh's post-revolution politics. A new clause in the ICT Act that disqualifies people from public office the moment churches are formed, and the simultaneous push to ratify the July Charter through a referendum. This is not just about law or politics in isolation, it's about the three pillars of justice, democracy, and stability. What strengthens the republic and what risks undermining it? Let's explore together. A new section 20C has been added to the ICT Act. Once formal charges are framed, a person can no longer contest parliamentary elections, nor local government elections, nor hold any service of the Republic. This disqualification takes effect even before the tribunal decides whether to take cognizance of the charges. With the Gazette now issued, the provision is in force that is the law of the land. One cannot grasp its full significance without weighing its criminal law fundamentals and political fallout together. First, the provision places a direct strain on the presumption of innocence. In most democracies, including examples in our neighborhood, the threshold for losing eligibility to hold public office is conviction, not sentence, not the investigation or charge stage. Bangladesh had already limited certain remedies through Article 47A of the Constitution in war crimes related cases. The state has now taken another step on that legal tradition. The question is this: is that on one more step a necessary condition for state reconstruction or an excess weight on the scale of justice? Second, the immediate political impact is immense. In the wake of the July-August turmoil over the past year, the list of those accused of crimes against humanity is both large and high profile, so the instant a charge is framed, major vacancies could emerge in electoral competition and in public appointments. This is immediacy of disqualification will trigger a new incentive crisis in politics, forcing parties to recalculate everything from candidate selection to coalition strategy. In the same continuum, the path to organizational or collective liability has also been opened in law. With the addition of Section 20B, if the tribunal finds it apparent that a party or organization committed, ordered, attempted, abetted, incited, instigated, or conspired to commit offenses, it may impose wide-ranging remedies, from suspending or banning activities to cancelling registration and seizing property. We have already seen a preview in practice. The interim government has imposed activity bans on a major political party, and formal steps toward tribunal action are underway. This is a historic experiment at the tri-junction of state, law, and politics. Here arises the third order question: procedural legitimacy and popular mandate. In implementing the July Charter, a policy terrain is taking shape where political parties have reached principled consensus on holding a referendum, yet there is a clear split over the when and the how. Some want the referendum on election day, others want a constitutional order to set the architecture first and then seek the people's approval. Each option has its legal administrative notes. A roadmap is possible, but it must be precise. Bangladesh's referendum history also cautions us. The three referendums of 1977, 1985, and 1991 all followed a single question, single answer model, each embedded in a powerful political context. If the present proposal seeks multiple questions or a package style approval, then everything from ballot design to counting methods will require brand new rules of the game. If we get it wrong, the result will be disputed. If we get it right, the mandate will be solid. There is no middle path. There are further legal thought or detail. On one side lies the interpretation and application of a recent court ruling that may have revived constitutional provisions on referendums. On the other side lies the need to amend the existing Referendum Act 1991 and the Representation of the People Order 1972. The institutional architecture must be built so that no vacuum, no legal void arises either before or after the next parliament is formed. That demands political will as well as fine-grained drafting craftsmanship. Now to the direction of state policy. Yours and mine has long been clear. You cannot strengthen democracy's foundations by weakening the foundations of justice. But justice rigor cannot endure if it ignores the people's legitimate demand for security. Therefore, at least 3 safeguards should be attached to a disqualification upon charge provision like Section 20C. First, a brief quasi-judicial screening led by a senior judge prior to charge framing to filter out frivolous or politically motivated cases. Second, a firm time limit, say 180 days, such that if a case does not move from charge framing to trial within that window, the disqualification is stayed. Third, a de minimis threshold, where allegations that do not meet the gravity standard of crimes against humanity do not trigger this section at all. Writing such safeguards into the law would reduce the risk of political misuse. On organizational liability, the minimal principle should be this: no collective punishment, only proven collective crime. When the tribunal holds the power to ban an organization or forfeit its assets, the preconditions, evidentiary thresholds, and appeal mechanisms must be unassailable. That way, victims receive redress while the state is less vulnerable to accusations of control politics over opponents. What has already been done, temporary bans, preparations for tribunal adaptation shouldn't be treated as final. To prevail in a court of law, both case theory and evidence must be ironclad. On the referendum, our pragmatic counsel is this: first, issue a constitutional order or equivalent normative instrument to put the indivisible parts of the July Charter into effect. Then take those to the people for approval through a single question mandate. The 70 to 75% of issues on which political parties already agree, that is the heart of democratic consensus. Attempting to present the disputed note of dissent items to the public in one package is both difficult and potentially confusing. Leave those to party manifestos and let voters choose. Then let constitutional amendments proceed in open parliamentary debate after the House is formed. That way, the referendum remains pure and the election remains meaningful. One more task cannot be neglected: a public awareness roadmap. A referendum is not a technique, it is a moral test of public will. Ballot language must be simple, the campaign must be information led, and state and election management structures must show visible neutrality. Our history shows when a referendum is held in the wrong context, the people become alienated. In the right context, moral legitimacy doubles. The lesson of 1991 was clear. Ask a clear question, get a clear answer, and return peacefully to a parliamentary system. Today's context is different, but the lesson endures. Finally, the state stands at a three-way intersection. Justice, democracy, and stability must move together. Section 20C sends a swift policy signal: zero tolerance for crimes against humanity. But unless that signal is bound firmly by the rule of law, it could tip into political emptiness. In parallel, Section 20B's organizational liability tools must be made evidence driven and appeal protected so that both deterrence and justice are served. And the referendum, let it be one question, one verdict, one mandate on the consensual core of the Chula Charter. Only then will this reconstruction be more than political choreography. It will become a moral plea to honor the martyrs, a plea that will outlast the tribunal's talk, live through the debates of the next parliament, and above all, settle in the hearts of the people. You have been listening to my podcast with me, Zillur Rahman, as we have discussed for Bangladesh to move forward. Justice must be safeguarded, democracy must be credible, and people must be given a clear mandate. A single question referendum, robust legal safeguards, and evidence based accountability are not just technical details, they are the essence of legitimacy. Thank you. Thank you for tuning in, and I look forward to continuing this journey of analysis and reflection with you in the next episode.